Thank you for joining us. This is Live with Miami's Community News, and our guest today is Boris. Tell us your last name again, Boris.
You're not falling for the same trick this time. Boris Zhadanovskiy.
All right, so we got it. All right, and you're with SearcyLaw.com. All right, that's a great web address.
That's the website. It's Searcy, Denney, Scarola, Barnhart, and Shipley. We practice in the state of Florida. We have offices in West Palm Beach, Tallahassee, and Tampa, but we do service all of the state of Florida. We travel all over the state prosecuting cases on behalf of the injured victims. I personally have represented people from Jacksonville, Pensacola, Ocala, Miami. Really, you throw a dart at the map of Florida, it was likely that I've had a client that either lived in that area or very close nearby.
And, I'm glad you brought that up, because so often we think, well, it has to be somebody in the neighborhood, if you will. But the reality is most of the things that we do here at Miami's Community News is that most of those suppliers are up there somewhere floating around. All right. When we send people home, they say, oh, I'm nervous. There's nobody at the office. I said, Gmail's never been at the office. All right. Oh, really? I go, yes. All right. When we do the artwork, and most of our writers haven't been here in years. All right. Some have been writing for us for 10 years. I've never met, not even on Zoom, because it was all fine to be able to do that.
So to that point, especially now, and you mentioned Zoom, we've represented people all over the state of Florida before Zoom or before the pandemic, but now it's easier than before. Everything can be signed electronically. You can meet via Zoom. You can meet via Teams. You can meet via Google Hangouts or whatever the next platform is going to be. And our law office offers all of those services to anyone in the state of Florida. If they're injured in Pensacola and they want to retain our services, not only can they use the Tallahassee office, and the attorneys that are in the Tallahassee office that are a bit closer, but if they want a specific attorney from the West Palm Beach office, they'll get exactly the same service that they would with a smaller law office that may be next door, that may not have the same resources and the same brand recognition that we do.
And certainly some of that is going to last forever. All right. We know we've seen mediation from law firms going back and forth. We've seen city commission meetings, county meetings, national, international, and even surgery across the world. All right. Via some sort of cameras. So with all the folks that were staying at home, all right, during the pandemic, and so now they're starting to venture out, and a lot of them have had pets, all right? Some just during this time that haven't had too many people come over to the house. And we know what happens, all right, is the pets get nervous. The doorbell, the dog starts barking like crazy. And then the poor guy at the door, all right, when the mom, dad, kid opens the door, and Fido over here was terrific and gets out and bites that guy. All right. Now what happens? All right.
Well, no one wants to be presented with that situation. I think that is a nightmare scenario for a lot of pet owners, myself included. My wife and I have two dogs. One is extraordinarily friendly and wouldn't hurt a fly. And one, even though he's extremely sweet and extremely kind, he has an anxiety disorder. So he, like in the situation that you described, gets very worked up, very anxious, and sometimes if he's not given the appropriate space or the appropriate opportunity to calm down, could act out in a way that could injure someone. So in that scenario, the dog owner is generally liable for the actions of their dog. And it's called, in the state of Florida, it's called strict liability. So if you're walking on the sidewalk and a dog, grabs you, whether you were walking too close or not, that will come into evidence, so to say. But the dog owner is generally liable for any misdoings from their pets.
Do insurance companies, and we no longer have dogs, all right? We used to, some Rottweilers and et cetera. Do insurance companies, on average, insure homeowners with dogs?
You have to be very cognizant of what insurance coverage you're purchasing. And it is one of the most common exclusions that I see in my practice when we get a copy of a homeowner's policy for, premise liability case. Let's say somebody slipped and fell at somebody's home, and we get their policy, and there's almost always an exclusion for any injuries or bodily injuries related to pets. Now, that is because the homeowner simply didn't read their policy to make sure they had one that would have their pets included. So if you know that you have a potentially, I don't want to call them dangerous animal, potential misunderstood animal that might act out, it would behoove those individuals to read their homeowner's policy, to make sure that there is not a pet or dog liability exclusion in their policy, which it likely is. And if it is, then to purchase a separate policy specifically for animal liability, which do exist. Now, you will see anyone who's rented, which most of us have, it's mandatory that in their renter's policy that there's liability for animals, because the property owner who you're renting from doesn't want to be held liable and doesn't want any questions asked. So actually on renter's policy, it's more common to see liability for animal actions than you would see in a homeowner's policy where the insurance company sneaks in an exclusion and never says anything.
And most people would not know until there's a claim.
And most people do not know until there is a claim and they go to their insurance carrier and says, oh, your dog's involved? Sorry.
So when does a homeowner who befriends a lost dog that's walking down the street, starts feeding him and watering and the dog, and he's staying on your property, when does it become his responsibility?
I think there's no strict guideline. There's no law that says if you fed a dog 7 times, he's now your dog. It's all factually specific. And an argument could be made if you are encouraging this dog to be on your property, and you fed him a couple times and you know that he's on your property and he could potentially be dangerous, you could be held liable for that animal.
And not to scare the homeowners, but if you get bit by a dog and you wind up going to the hospital, it's infected, blah, 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 and you recover from it, more or less, what's the range, all right? No permanent damage other than psychologically scarred, running from every chihuahua that you see. What's the range of potential liability for a non-insured person?
Well, as you alluded to, it all depends on the magnitude of injury. If it's a small puncture wound with absolutely no additional treatment, doesn't get infected, and takes 1 stitch to fix, a couple $1,000s. If it is a deep laceration, potentially involving muscle tissue, dog bites are generally not minor by nature because it's a puncture wound, and a puncture wound goes deep. There's potential reasons to believe that there's going to be an infection and additional treatment. If I'm not mistaken, the insurance industry releases what general claims for certain events are. And I think for dog bites, it ranges anywhere between $30,000 to $60,000 for liability.
So they should either not have dogs or have insurance or have a bunch of money.
As with everything in life, you insure for what your potential exposure may be.
So we live on a farm. My wife raises exotic animals and birds. So we had in a cabana outside a table with in a cage, and we had 6 or 7 baby birds, letting them enjoy the sunshine, getting used to it. And the cage is on the table. A little while later, we look out to the window. The cage is gone. We go out there. The cage is on the ground. 2 dogs from next door got into the cage and killed 6 of these baby birds. A couple of the bodies were there, and I knew where they were from. So I start taking pictures, right? I walk over. I see the picture of the birds dead on their property. It was from a rentor, from the lady that lives there. And there was a dog with a bird in its mouth. So I take all the pictures. I call the police report, all right? And they came over, said, here are the pictures, here are the birds, like this. So I went to the owner of the property. I said, you're a tenant, all right? Dogs, all right? Came on my property and killed these birds. And then it turns out that they forgot to get their papers when they came over. And so they were scared enough, all right, to pay us. But the owner of the property, she knew that she had liability with that. And so because I'm thinking, I have to be able to prove this. And there was this dog with this bird in its mouth. And so the point was, we didn't do anything wrong. We did it properly. They were in a cage, all right? And the dogs had gone 200 feet into the property. Eventually they got rid of the dogs, because once they have that experience, they know what to do.
The negative propensity.
Yes. So lots of times, even when somebody else is responsible, you still have to do things, all right? So if you have a big dog, all right, that if a big dog is chasing somebody and the dog doesn't bite, but because the person's running, they hurt themselves, what's the liability?
It's like a mean law school question. And as with so many things in the legal industry, because there is no way to codify every single possible scenario that could ever occur. This would be a factually specific issue. And it would depend on what are the actions of the owner that led to this individual being chased by the dog and ultimately being injured. If the individual jumped a fence and he's in the owner's yard, then I think the person who jumped the fence is likely at fault. I don't know that the owner would be held liable for having his own dog in his own backyard and having a trespasser on his property. If the dog owner in this scenario walks outside with his big dog and takes him off leash in a public area and that dog takes off, well, then the dog owner is likely responsible under those circumstances. So it all depends on what led to the situation where the dog is chasing the person.
So, and lots of people are afraid of even the little dogs, all right, where they're just, they're running around you and they're snapping at you. And so some homeowners think that it doesn't matter. It does matter, all right, because nobody wants to be chased, even if standing still with that dog running around. So let's also talk about general liability, all right? Somebody comes over to your house, they're at a party, and they slip and fall, all right? And you have insurance, and the person gets injured. And they can prove their injuries by virtue they go to the doctor or the emergency room or whatever happens. What's the process for both people, the homeowner and for the victim?
So the homeowner is, if they have homeowner insurance, the process for the homeowner is very easy. Notify of the potential claim to their homeowner's carrier as quickly as possible. Somewhere deep down in that packet that the insurance carrier gave you when you bought the policy, there's a provision that you have to notify them as soon as practicable or as soon as reasonable. Does that mean the very next day? Probably not, but I would say within the next couple of days, right? Let them know. Call your agent, call your adjuster, call whoever, the underwriter that sold you the policy. Make sure that they know of this potential claim. The person who's been injured, the first thing that they need to do is make sure that they attend to their injuries. Right? They shouldn't be thinking, even though it's hard to differentiate, but they shouldn't be thinking about insurance. They shouldn't be thinking about making some sort of financial recovery. What they should be focused on, if they are really injured, is getting the treatment that they need. Do they need to go to the ER? Do they need to go to the urgent care? Do they need to go wait till an appointment with their family care practitioner? Do they have an orthopedist in the family that they need to go see? That should be the number one thing that they're worried about is their health. Right? Because failing to go to the hospital could make your injuries potentially worse in certain circumstances. After that is when they start worrying about insurance. And I always say, call an attorney. It's what our job is. It's what we do on a daily basis. But without, that quip, I would also say, make sure that the homeowner whose house you were at is notified that you were injured, is notified that you are in the hospital. If you want to, you can ask them for their homeowner's insurance contact, and you can reach out to them and open up a claim to make sure that it's on their file. And then you get into the legal mumbo jumbo, so to say, of is it really the homeowner's fault? And there's a whole area of the law called premises liability, which encompasses your trip and falls, your slip and falls, as well as other injuries that could occur on a property. Premises, of course, meaning property, and liability meaning fault.
Let's talk about if you own a condo, they park their car and they're in the parking lot and they hurt themselves. That goes to the condo association liability.
Exactly.
Right. And when does it become the homeowner's, the condo owner's responsibility if somebody falls?
Well, it all depends on what your documents look like. Are you, as the homeowner, responsible for maintaining the sidewalk? Now, in my experience, that would be, I've never seen that in my experience, that if you live in a condo, generally the homeowners association or the management company is the one that's in charge of maintaining the sidewalks and the other common areas. And generally, the homeowner or the condo owner is responsible for whatever happens behind the threshold of their house. That's how it normally is. But again, there could be exceptions.
So if somebody lives in a townhouse and it's the townhouse is set back 4 feet, out front is the porch, if you will, the sidewalk, that's the homeowners, or is that the condo association, or both?
Depends on who's supposed to maintain it. And that would all be found in the documents for the association. Generally, they delineate exactly who's responsible for what. The stoop could potentially be the homeowner's issue, and depending on what the issue is on the stoop, would also go into the equation of who's potentially responsible. If the owner has electric wires hanging down in front of the steps to his house that are live, it's probably the homeowner that's responsible for that. But what if you find out that the homeowners association is responsible for the lighting that's above the stoop, and they just had a contractor come out and the contractor left the wires? It's infinitely more complex than just saying, here's the line. It's the homeowner on this side of the line. It's the association on the other side of the line.
So let's talk about, let's say you park your car in a shopping center and you're walking, to go into the grocery store. And, these grocery stores, they have these beautiful palm trees out there, 20 feet tall, and you're walking, and all of a sudden that 10-pound palm frond falls, all right? And the tree's not rotten, and it's a good tree, and it falls and hits you in your head, and you get hurt. What's the law concerning stuff coming down from trees?
So there's no specific law on stuff going down for trees. Again, it's all dependent on, well, let's take it back a little bit. What is the duty of a landowner, generally speaking, to invitees on his property? So somebody that's going to a grocery store that parks in front of the grocery store is an invitee on the property.
Yes.
They plan to shop at the store. A landowner owes that person two distinct duties. One is to warn of potential dangers that the landowner is aware of and that the invitee is not aware of. All right. In this situation, the landowner may be aware that the trees are likely to drop their fronds. However, that one would be a little bit more open and obvious. So there's a gray area with that duty in this circumstance. But the second duty is right on point. The landowner has a duty to the invitee to keep its premises in a reasonably safe condition. And, that is so open to interpretation. What is reasonably safe? Who knows? And for that, we employ experts. So in that situation, if the palm frond fell on someone, it would be the personal injury attorney's job to first figure out what the maintenance on those trees were, whether appropriate maintenance had been performed, and if appropriate maintenance was not performed, is that what caused the palm frond to fall and injure someone? And potentially you'd need I believe they're called arborists, tree specialist, that could come in and say, this tree should have been trimmed every 3 months. It wasn't, and this caused the injuries to the unfortunate invitee.
So if you're the average property owner and you're doing some things, If you're not taking care of the property and there's a problem, all the stuff that you probably should have done could come back and bite you.
Could come back and bite you. And especially if something that you should have done, that a reasonable property owner would have done, and that specific failure led to somebody being injured on your property.
So let's say somebody's walking along the sidewalk of a city, all right? It's within the city and it's city property. And you know, those coconut palms, man, they love to pull that sidewalk up. And let's say the city's been notified, hey, there's a 2-inch lip on this over here, all right? And somebody's going along and maybe on a bicycle, all right? Or walking, all right? And they fall and they really hurt themselves. And it's clear that the sidewalk was a hazard. What's the liability of the city if they've been notified ahead of time and if they've not been notified?
So that's an interesting several-part question. So let's take it in parts.
Okay.
What's the liability on the city? And because the city is what the state of Florida considers a sovereign immune entity, their liability is capped. I mean, there are statutory caps that the city can defend against any catastrophic injury. And the cap, without getting into the specifics of how the caps are lifted, how you can argue that the cap's not applicable, how the caps work with more than one injured person, the cap is generally $200,000, which, you know, back in, I think, the 1970s when the caps were first put in was a pretty significant sum of money. But as we know, looking at the medical bills that people receive nowadays, you know, $200,000 is about a night in the ER in today's time, which is a, you know, whole other conversation that we could have. All right. So the city, they are liable, first of all, but their liability
in either case,
they're liable. Their liability is likely to be capped because they're a sovereign immune entity. If they're on notice, then that's easy, right? They're already notified of a potentially dangerous condition. They failed to warn of a potentially dangerous condition unless there's a sign that they put up next to the lip saying, be careful, there's a lip. But even if they put up the sign, that does not alleviate the second duty of keeping their premises in a reasonably safe condition. And having a large lip on a sidewalk is almost by definition not reasonably safe.
So do the courts, or is there a law that says, listen, this injury is $20,000, but because you knew a month ahead and you didn't do anything, does it therefore a punishment, if you will?
There are what are called punitive damages, and punitive means to punish. Right? Generally, the damages that we ask for before a jury are 1, economic, 2, non-economic. What are economic damages? It's your medical bills. It's your lost wages. It's loss of future earning capacity, amongst other things. And then you get into the non-economic damages, which, as you hear on TV and in the newspapers, is pain and suffering, disfigurement, permanent disability. All of those are tied to the specific injuries that have been caused. Then you have another facet of potential recovery called punitive damages. And those damages are there purely to punish for wrongdoing. If somebody does something that is so shocking to the conscience and so cold and is basically going to lead to someone injured and they know it, then the courts could recognize those punitive damages.
But typically those type of things, just because they haven't done it, it's not intentional in the sense of like punishing the public, so they're going to leave it there. All right. So let's talk about the proverbial banana store and a grocery store, banana peel. So it's there on the ground and you see it, all right? And you absolutely 100% see it. And you don't do anything to avoid it. And let's say the camera is there. Let's say you stop and you saw it and you just didn't step 1 foot over to miss it. What's the responsibility of the injured or the pre-injured person when they see that there's a hazard, even if there's no yellow or orange cones around it?
So Florida employs what's called pure comparative negligence, all right, which means that both parties can be at fault, and it would be for the jury to decide what percentage of fault to assign to each party. In that circumstance, you could see a jury saying that the person that saw the banana peel, saw that it was on the ground, and chose to slip on it is 100% at fault for causing the injuries to himself. However, evidence could be presented that the store knew of that banana peel, that they were warned that there is a potentially dangerous condition on one of its aisles, and that they elected not to pick it up. They elected not to clean it up, and they left a potentially dangerous condition. It would all depend on what the jury wants to do with that information. And a jury could say it's 50-50. You shouldn't have left it there, but that person shouldn't have slipped. Or the jury could still decide it's 99% on the person that elected to walk over it. Or the jury could decide it's 99% on the store, as unlikely as that sounds. And the jury would be presented with all the evidence, and it would be up to the jury to decide under those circumstances, but with the caveat that it would have had to have, the banana peel would have had to have been there for some period of time that a reasonable store owner would have been put on notice that it's there.
Gotcha. Okay. Let's talk about, if we could, if you're somebody in the construction business and you go out and you build something and it fails. There was a recent case, without naming who it was, that all the suppliers that provided the material that was ultimately used in this product, all with the exception of one, wound up settling with the victims, right? Even though the guy that made the concrete, all he did was deliver the concrete, right? But they all settled. Why do big companies do that? Or any companies?
There's a lot of different motivations that go into any sort of potential insurance claim and the end result of potentially settling. And without knowing more information, without knowing the magnitude of the injuries, and I just based on what you told me, I presume that the injuries were absolutely heinous and that there were deaths involved.
Yep.
Those companies or their insurance carriers, more likely the insurance carriers, don't want to even take a shot at rolling the dice to see what a jury may do. Right? They may want to limit their exposure by controlling what they pay.
Oh, good. So that lots of times that is a decision. Listen, today it's going to be X dollars, and tomorrow it could be X plus or X minus. And then, of course, all the legal fees that are involved in months. One time we had a very big case, gigantic case. And I said to my attorney, how do you get big cases? He says, like yours? I said, no, how do you get big cases and get big fees? So I said, we know that lawyers protect the rights of people. And then when you're injured and you need to be compensated for that, because some injuries are forever, right? We see that frequently, whether they're self-induced, all right, or through somebody's negligence. So you've made a decision in your practice to represent, I don't want to use the word victim, what's the
injured individuals.
The injured,
and as I think as I would put it, those that have been injured due to the negligence of others.
So it must be rewarding when you can prove either to a jury or to the other side or to the judge, and listen, because of this, what happened over there, and to their negligence, my client has this injury and they're suffering and they can't walk right anymore, or their shoulder is out of whack. It must be fulfilling to be able to come to the rescue and be able to help them.
It is incredibly fulfilling. I think that would even be an understatement. We as attorneys, especially those representing injured people, come into the fold, so to say, during people's most difficult times. I mean, truly, they were just, in a horrific car accident where they lost a loved one. They were just done with a surgery that left them paralyzed. One of their family members has just died in a plane crash. I, as an attorney, am able to sit down across the table with them and help them in the first steps just to get their mind pieced together and take one one facet of what they have to do off of their plate and put it onto my plate. All right. They don't need to worry about the insurance. They don't need to worry about making sure that the estate is set up. Right. We serve as a conduit to help them in their time of need. Now, we cannot be the funeral director. We cannot arrange for the funeral, but we can take some small pieces off of their plate at that juncture to make their life a little bit easier. And that's the very first step that we do. And of course, everything else comes after, right?
And it's obviously a great relief for somebody to go in who's been injured or their family member injured or died, to be able to go to a place and go, I need some help. And as you're saying, that's off your plate. We're going to take care of that. You got some other issues you need to tend to. I'll bet lots of times you're when you listen to people and you see the pain they're in, you know, that you must feel for them, especially if they don't know what to do. So you give them direction, be able to help them in this process, which sometimes can be months and years, right? So people have to understand that it's not like a simple thing, right?
One of the most common questions I'm asked during these initial meetings, whether they're in person or via Zoom or via telephone, is how long do you anticipate this matter is going to last? How long does it take to settle a claim? How long does it take to try a case? And it's difficult to tell people why it takes so long. And you know, there are cases that settle within weeks, but the vast majority of them will take months, will take years, and I've worked on cases that took a decade.
So even if they are right and the other person's wrong, that's just the way it works, all right? It's going to take a while to sort through all the things because the other side is going to have the defense attorneys and they're going to try to figure out something that makes everybody not necessarily happy, but get people to where they're somewhat okay with what occurred. And there's an old saying that the best settlement is one that you're not very happy with and that I'm not very happy with.
I was about to use that same statement.
And that's the way it is. So, Boris, we're gonna wrap it up here. Why don't you give folks your website address and if they want to reach you?
Sure. My name again is Boris Leonidovich Zhadanovskiy. I threw in my middle name that time. The website is Searcy Law, SEARCYLAW.com. And the law office is Searcy, Denney, Scarola, Barnhart, and Shipley.
That's great. And now you know why he got to do that. So probably in a couple of days, I'm going to call Fair in the middle of the night and I'm going to say, Fair, how do you say his name?
Well, I saw the prompt come up and I actually forgot how to spell because I was trying to read and say it at the same time.
Anyway, I'm delighted to be able to talk with you, and you're a sincere person, and you have that nice blend of caring about people and being able to take care of them and understanding some of their medical issues and the social issues that are connected to injuries. So my hat's off to you.
Oh, thank you.
Thank you very much,
Boris.
Boris.
A pleasure.
Hey, folks, thank you very much for tuning in. Again, you can find Boris at SearcyLaw.com. You find him all over did I get it right?
Close enough. It's on the screen now.
Oh, there you go. Right there. There you go. There it is. It's right up there. Howard, thanks so much. Folks, have a great day and appreciate your time.
Thank you
Bye.
all.